Understanding the law is the first step to fighting back. Springfield, Ohio. Population 58,000. And for the past several years, home to somewhere between 12,000 and 15,000 Haitian immigrants, most of them living and working legally under a federal program called Temporary Protected Status. In the early hours of February 3rd, 2026, those families came within hours of losing everything. Temporary Protected Status, TPS, is a federal program created by Congress in 1990. It allows people from designated countries to live and work legally in the United States when conditions in their home country make return unsafe. Natural disasters, armed conflict, collapsed governments. Haiti first received TPS designation in 2010 after a 7.0 magnitude earthquake destroyed much of the capital city and killed over 100,000 people. Since then, Haiti's TPS has been extended multiple times. Gang violence controls enormous portions of the country. The rule of law has collapsed. The State Department currently issues a Level 4 advisory for Haiti, its highest level, advising Americans do not travel. In November 2025, Secretary of Homeland Security Kristi Noem announced that Haiti's TPS designation would end at 11:59 p.m. on February 3, 2026. Her stated reasoning? Haiti no longer meets the conditions for the designation. The administration argued there had been notable improvements in the country. More than 330,000 Haitians across the United States held TPS at that moment. In Springfield alone, the potential impact was immediate and enormous. On February 2, 2026, one day before the termination deadline, U.S. District Judge Anna C. Reyes in Washington, D.C., issued an 83-page opinion and a court order blocking the termination. The case is called Miot et al. Versus Trump et al. Judge Reyes found that 5 Haitian TPS holders were likely to succeed on the merits of their challenge. Her findings were specific and pointed. The government's conclusion that Haiti was safe for return was, in her words, arbitrary and capricious under the Administrative Procedure Act. The administrative record before the court described Haiti as facing widespread violence, mass displacement, collapsed institutions, and severe humanitarian conditions, including that State Department Level 4 travel advisory. The agency concluded Haitians could safely return, but could not identify a single safe region in the country. The court also found substantial indicators that racial and national origin animus may have influenced the decision-making process, pointing to statements made by senior government officials and inconsistencies between the agency's stated rationale and the evidence in the record. The practical result: Haitian TPS holders retain their status. Employment Authorization Documents remain valid by court order, even cards showing expiration dates that have already passed on paper. Employers must continue to accept them. On March 6, 2026, the D.C. Circuit Court of Appeals, by a 2-to-1 vote, upheld Judge Reyes's order. Haiti's TPS remains in effect while litigation continues. 3 days later, on March 9th, the Department of Justice formally asked the Supreme Court to intervene, to overturn the injunctions and allow the termination to proceed immediately. This matters. The Supreme Court already ruled against Venezuelan TPS holders in a similar case last May. The court allowed the administration to end TPS for Venezuela, even while lower courts had ruled otherwise. That precedent creates real legal risk for Haitian TPS holders now. If the Supreme Court agrees to take up the case, or grants what's called an emergency stay, the protections could end with very little warning. Days, possibly. TPS holders and the employers who work alongside them need to be watching for any Supreme Court order in this case. The government's core argument is that federal courts should not second-guess the executive branch on immigration and foreign policy decisions. Courts, the administration argues, are interfering with the president's authority to set immigration priorities. The dissenting judge on the D.C. Circuit agreed with this view, arguing that the Secretary of Homeland Security has broad statutory authority to make TPS determinations, and that courts should apply a very deferential standard. That is a real legal argument with real legal force. The outcome of this litigation is not certain. What is certain, right now, today, Haitian TPS holders are protected. Their work authorization is valid. They cannot be removed solely on the basis of TPS termination while this court order stands. Now let's talk about what was happening on the ground in Springfield while families waited for that February 2nd court ruling. In the days leading up to the deadline, Haitian families began withdrawing from daily life. Children stayed home from school, workers called out, people disappeared from churches, from community centers, from jobs they had held for years. A teacher named Anna Petit described it plainly. We all witnessed the disappearance of members of our community. And in that moment, something else happened. Quietly, without announcement, some of their neighbors opened their doors. Volunteers converted spare bedrooms and finished basements into places of refuge. A network took shape, not through spreadsheets or cloud-based lists, but through handwritten notebooks and vetted personal contacts, kept deliberately offline for security. One woman, identified only as Lee, in her 70s, welcomed a Haitian mother she had never met and her 1-month-old infant. She prepared the bedroom. She gave them a tour. She waited alongside them for the court's decision. This network echoes something Springfield has done before. The city was once a documented stop on the Underground Railroad. On U.S. Route 68, the former home of George and Sarah Gammon, both of whom had been enslaved, now stands as a museum. That house was a way station for people escaping bondage. The connection is not lost on the people living it now. Here is what you need to understand about the legal landscape for sheltering immigrants. Federal law makes it a crime to, quote, conceal, harbor, or shield from detection an unauthorized immigrant. That law carries a potential sentence of up to 5 years in federal prison. The key legal question is whether the person being sheltered is actually unauthorized at the time. TPS holders have legal status. Their presence is lawful. Sheltering a TPS holder is not harboring an unauthorized person. But TPS status is subject to termination. If the Supreme Court grants an emergency stay and the program ends, potentially overnight, the legal picture changes. Anyone in those homes at that moment could become undocumented in a matter of hours. Attorneys advising communities in Springfield have been clear. If you are sheltering someone you know immigration enforcement is actively and specifically pursuing, you may enter territory classified as harboring. This is not a hypothetical. It is a real legal risk that anyone participating in these networks should understand and discuss with an attorney who specializes in criminal law before taking action. What is also legally clear: ICE agents do not automatically have the authority to enter a private home without a judicial warrant. The distinction between a judicial warrant, signed by a judge, and an administrative warrant matters enormously. You have the right to ask. You have the right to record any encounter with law enforcement, as long as you do not physically interfere. Springfield's own police chief confirmed this on the record. If you hold TPS right now, here is what is actionable today. Your Employment Authorization Document is valid, by court order, even if the printed expiration date has passed. If an employer questions your card, point them to the court order in Miot versus Trump. USCIS has officially confirmed this extension. Do not stop working. Do not surrender documents. Do not assume the worst until a final court order changes the situation. At the same time, explore your options. TPS is not a pathway to permanent residence on its own, but depending on your circumstances, there may be other pathways available: asylum, family petitions, employer sponsorship. Speak with an immigration attorney about your individual situation. Every case is different. Document your life in the United States. Employment records, tax filings, school records for your children. medical records, lease agreements, community ties, evidence of residence. These records matter for any future immigration proceeding, for any future application, for demonstrating your place in this country. Know your rights at the door. ICE agents require a judicial warrant signed by a federal judge to enter your home. An administrative warrant is not the same. You can ask to see the warrant through the door. You do not have to open it. You have the right to remain silent. You have the right to speak with an attorney before answering questions. Stay informed and know your rights. Record today, protect tomorrow.